All right, good morning, everyone. Let's call the case of Marks versus Sunny's Rooftop Bar to order. Let's start with appearances from both parties, beginning with the plaintiff.
Yes, Your Honor. Good morning. My name is Paul Atherton, and today, alongside my co-counsel, Ms. Gabriella Ravel, we represent the plaintiff, Ethel Marks, in today's matter.
Thank you, Mr. Atherton. Defense?
Yes, Your Honor. Good morning, Your Honor. My name is Jack Spillner. On behalf of the defendant, Sunny's Rooftop Bar, I'm here with my second chair, Natalia Ortega.
Good morning, Your Honor.
She will be timekeeping and screen sharing exhibits and demonstrative aids. That concludes the introductions from the defense, Your Honor.
All right, thank you very much, both parties. I'm going to take it back to the plaintiff for a second. Do you have any preliminary matters you want to take care of before we press on to opening statements?
Yes, Your Honor.
Go ahead.
We would direct the court's attention to a couple pretrial orders. First, pretrial order 3. As it states, the defense's previous affirmative defense of contributory negligence on behalf of Morgan Levin has been dismissed via summary judgment. Additionally, we would direct the court's attention to pretrial order 13, as it identifies that at all times relevant, Frankfurt Johnson and Sunny Mehta, two employees of the defendant, which is Sunny's Rooftop Bar, were acting on behalf of the defendant. Additionally, Your Honor, the plaintiff requests to utilize Exhibit 2, a picture of Jessica Marks, in our opening statement. We mean it on a good faith basis that we intend on entering this document into evidence for the first direct examination.
All right, defense, any objection to that request?
No objection to Exhibit 2, Your Honor.
All right, that's fine. I think given your representation that you will have a good faith basis, it will be admitted, and I think that's fine. You can use it in an opening statement.
Thank you, Your Honor.
The defense has some.
Okay.
Yes, Your Honor.
Hold on, I just want to clarify that's it from the plaintiff?
Yes, Your Honor.
All right, defense, go ahead. Any other matters?
Yes, Your Honor. We would also like to draw your attention to another pretrial ruling, pretrial evidentiary ruling 11. It states that exhibits 1, 22, and 23 are pre-admitted and their contents may be used at any time.
All right, that's my understanding of the order, and I see that in addition to the ones that the plaintiff noted as well. So the court has noted all three of those.
Yes, Your Honor, and we would also request that all witnesses be constructively sworn in.
All right, that's fine. Any objection from the plaintiff or any issues with that?
No objection to that, Your Honor.
All right, all witnesses will be presumed sworn when they take the stand.
Nothing further from the defense, Your Honor.
All right, thank you both parties. And with that, let's proceed to opening statements. Mr. Atherton, you may proceed whenever you're ready.
Yes, Your Honor. May I transition to the well?
Of course. And I'm going to just note for all of our spectators and panelists and judges, let's switch to speaker view so we can better see our attorneys when they're giving statements. All right, Mr. Atherton, you may proceed.
May it please the court, members of the jury. The one who should have saved her was the one that served her. This was her. Her name was Jessica Marks. She was 19 years old. On March 24th, 2019, Jessica Marks was in Los Angeles, California. She was with her friend, Sunny Mehta. The two of them went to a bar that night, Sunny's Rooftop Bar. Jessica Marks became intoxicated toward the start of the night, and yet the defendant continued serving her drinks. After, Jessica Marks got into her car, started the engine, drove away, and died in the car. Members of the jury, that is why we are here today. We're here because the business that served her chose not to save her. Now, we are the plaintiff in today's case, but we have the burden of proof. We have to prove to you, by a preponderance of the evidence, which just means more likely than not, the defendant, Sunny's Rooftop Bar, is liable for the wrongful death of Jessica Marks. Now, today, we will fulfill our burden, and in doing so, we're going to prove three things to you. One, Jessica Marks was on March 24th, 2019. Two, The defendant continued serving Jessica Marks drinks after she was obviously intoxicated and free. Those drinks caused the death of Jessica Marks. Today, you're going to be hearing from Morgan Levin. Morgan Levin will testify that despite the fact Jessica Marks was obviously intoxicated at the start of that night, the defendant continued serving her drink after drink after drink. Morgan Levin will also testify Sonny Metz, the owner of the bar, saw Jessica Marks stumble down the stairs that night and responded to this by saying, "Whoa there, we might need to cut this one off." But he didn't. You'll then hear from Sonny Meza today. Sonny Meza will attempt to make you believe that Jessica Marks, a 19-year-old, 115-pound, 5 feet tall girl, was not intoxicated after drinking all of the alcohol. At the conclusion of today's case, you're going to learn how many times the defendant interacted with Jessica Marks in an obviously intoxicated state. You'll learn that in those instances, the defendant had opportunities to save Jessica Marks. But you'll also learn the defendant didn't take those opportunities. Instead, the defendant continued serving. That's why at the conclusion of today's case, I'm going to return to your screen and ask you to find the defendant liable for the wrongful death of Jessica Marks. Thank you.
Thank you very much, Mr. Atherton.
Defense opening, Your Honor.
Yes, Mr. Spillner, go ahead whenever you're ready.
Yes, Your Honor. Go hard or go home. Not ready to go home. This is what Jessica Marks said on March 24th, 2019, her last night of spring break. From the beginning, this was her plan, to go hard. That was her choice. And unfortunately, that choice and several others Miss Marks made eventually led to her death. It's a tragedy what happened to Miss Marks, but Sonny's rooftop bar is not to blame. She is. Now, at the end of today's case, you'll be asked not only whether Jessica Marks was obviously intoxicated, but whether Miss Marks was responsible for her own death under our affirmative defense of comparative negligence. And when you hear this evidence today, it will be clear to you that Sonny's rooftop bar did not serve Jessica Marks while she was obviously intoxicated, and that Miss Marks was responsible for her own actions. March 24th, 2019 was the last day of Miss Marks' spring break. She was visiting her friend Morgan Levin in LA and wanted to have fun. Unfortunately, her idea of fun was alcohol, despite the fact that she was only 19. Now, you'll hear today that Jessica Marks made the choice to rent a car. You'll hear that Miss Marks made the choice to go hard that night. You'll hear that Miss Marks made the choice to drink at her Airbnb. And you'll hear that even though she knew her plan was to go hard, Jessica Marks still made the choice to drive her car to Sonny's instead of taking an Uber. Now, you'll hear that all this happened before Sonny's rooftop bar ever served Jessica Marks a single drop of alcohol. But Miss Marks' poor choices, they didn't end there. Jessica Marks chose to order alcoholic drinks throughout the course of the evening, even though she was underage. You'll hear today that Miss Marks also had the opportunity to drive home in an Uber. But did she? No. Even though she'd been drinking, Miss Marks still chose to drive. Again and again, Miss Marks made those choices, and again, those choices added up, resulting in her death. Now, the evidence will also show that it wasn't even obvious that Jessica Marks was intoxicated. Sonny Meta would testify today that he served Jessica Marks, but didn't see her acting out of the ordinary. Now, Mr. Meta's testimony, it will be backed up by the only third-party eyewitness you'll hear from today, There was another customer at the bar named Stevie Rigg, and the evidence will show that he thought Miss Marks was not fall down drunk. And in any event, there wasn't much opportunity for any signs of intoxication to be obvious. Mr. Mehta was someone who was serving 12 to 14 other people at a given time, and someone who only spent around 30 seconds at Miss Marks' table when he served her. Mr. Mehta was working a job. Now, this case is about choices, ladies and gentlemen. Over and over again, Miss Marks made bad choices that added up. It's tragic that she died, but Jessica Marks' own choices are what led to her death. Therefore, at the end of today's trial, we'll ask you for a verdict of not liable. Thank you.
Thank you very much, Mr. Spillner. Let's switch back to gallery view before we move on to the plaintiff's case in chief. And with that, plaintiff, you may call your first witness.
Yes, Your Honor. The plaintiff calls Morgan Levin to the stand.
All right.
May I reposition, Your Honor?
Go ahead. Mr. Levin, you are presumed sworn.
Yes, Your Honor.
Once we get plaintiff counsel back on screen, there we go. Mr. Atherton, you can proceed whenever you're ready.
Good morning, sir.
Good morning.
Please introduce yourself to the members of the jury.
Hi, my name is Morgan Levin.
How old are you?
I'm 21.
Do you go to school?
Yeah, I'm a junior at UCLA. I'm also a research associate at Cloud Technologies.
Sir, I want to talk about why you're here today. Did you know a person by the name of Jessica Marks?
I did. Jessica was my best friend.
Ms. Rowell, can you screen share Exhibit 2 for us? Sir, do you recognize this picture?
Yeah, I do. That's her. That's Jessica.
Is it a fair and accurate image of Jessica Marks?
I'd say so. She looks so happy in that photo.
Does it look changed in any way?
No.
We offer Exhibit 2, Your Honor.
All right, any objections from the defense?
No objection, Your Honor.
All right, Exhibit 2 is received.
Sir, how did you know Jessica Marks?
It goes all the way back to middle school. We both went to River Trail together, and we were in the same biology class, and we were doing a project on where you had to identify the cell's organelles, and we were partnered up for that. And ever since then, we've been best friends all the way up until high school and even college.
Sir, do you know what happened at 11:53 p.m. on March 24th, 2019?
Yeah, I do. That's when Jessica left this earth.
I want to talk about that day. Did you and Jessica Marks go somewhere?
I apologize. Are you all able to see me?
Yes, sir, we can.
I'm sorry. Could you repeat your question?
Did you and Jessica Marks go somewhere?
We did. She had come over for a spring break to LA. She'd always wanted to do a spring break in LA, and so we decided to go to Sunny's Rooftop Bar.
What time did you arrive at the bar?
It was around 9 p.m.
Sir, did you and Jessica Marks drink that night?
We did order drinks that night from Sunny's.
Would you be able to recognize the beverages you consumed that night?
Yes.
Ms. Rowell, can you screen share Exhibits 11 through 16 for us? Sir, what are these?
These are pictures that I took from that night. Back then, I was really obsessed with my Yelp prestige. And so I always used to take photos whichever bar or restaurant I used to go to.
Are they fair and accurate images?
They appear to be so, yeah.
Do any of them look altered in any way?
No, sir.
We offer exhibits 11 through 16 into evidence, Your Honor.
Any objection?
No objection.
All right, 11 through 16 are admitted and received.
Sir, I want to confirm something. Who served you and Jessica Marks all of these drinks?
Well, it was Sonny Mehta, the person that owned the bar.
Well, sir, we talked about pictures you took that night. Did you take any videos?
I did. At one point in the night, Jessica wanted me to take a video of her because she had a lot of followers, and so I did that.
Would you be able to recognize that video?
I would.
Ms. Rowell, can you screen share exhibit 10 for us? Sir, do you recognize the first image of this video?
I do. It looks like Jessica from that night.
Does it look altered in any way?
No, it doesn't.
Does it accurately depict how Jessica Marks was acting on March 24th, 2019?
That's exactly how she was acting.
We offer exhibit 10, Your Honor.
All right, any objections?
Yes, Your Honor. I believe there will be hearsay in this exhibit.
Okay, let's consider this constructively. Go ahead. What's the hearsay issues that you're worried about in this video?
Your Honor, Jessica Marks is making statements that are out of court and that are offered for the truth of the matter asserted. Therefore, they are hearsay.
Okay, well, we're outside the presence of the jury. Are there specific statements? You can disclose what those statements are, what you believe they will be. What statements do you think will be said if we play the video that will be hearsay that is without exception?
Your Honor, I wouldn't point to a specific statement, but just the whole entire video within itself. If Mr. Atherton wishes to enter these for not the truth of the matter asserted, I will consider that.
Okay, well, I'll tell you, I viewed the video prior to trial. So if there's a specific statement you're worried about, you can disclose that, but let me just hear what Mr. Atherton has to say. Mr. Atherton, what's your response to that?
Under 801 section C, hearsay has to go to the truth of the matter asserted. We're actually using this evidence to go to the effect on the listener. So this is not hearsay.
Okay, and who's the listener in this case, and what effect are you representing that it had on them?
Morgan Levin, Your Honor. As a result of seeing Jessica Marks consume all the alcohol he just mentioned and filming this video, he came to the determination that Jessica Marks was intoxicated.
Okay, response from the defense?
Yes, Your Honor. As long as the jury will not be considering this for its truth, we would like to ask for a limiting instruction to not use it for those purposes.
Okay, and that sounds like both parties are amenable to that. So I will issue a limiting instruction to the jury under Rule 105 to that effect. So none of the statements in the video are to be taken for their truth, whatever they may be, whatever they may assert, and the video will be admitted and received with that understanding.
Thank you, Your
Yes,
Honor.
Your Honor.
Ms. Rowell, can you screen share, pardon me, can you play exhibit 10 for us?
Hi everyone, Morgan and I are in Hollywood. We're at a bar. It's kind of like a silly bar, except everything is really, really expensive. $10 for a seltzer. And everyone here wants to be a model or an actress. I'd like to thank the Academy. Mom and Dad, you've inspired me. Okay, well, go big or go home.
Mr. Levin, based upon the drinks you saw Jessica Marks consume that night and the filming of this video, did she look intoxicated?
Yeah, she did. Her eyes were watery, as you can see in that video. She doesn't know which can to pick up after she's done her thing. She's giving an Oscar speech on a rooftop. I mean, she looks so drunk in that video.
Sir, did she act this way when interacting with Sonny Mehta?
She did. There was that one time we were walking down the stairs and Jessica stumbled.
I want to talk about that time. Ms. Rowell, can you screen share exhibit 9 for us? Sir, are these the stairs that Jessica Marks stumbled down?
They are. I was on the upper half of the staircase, and she was on the lower half.
Is this a fair and accurate image of the steps she stumbled on?
They appear to be. Yes, sir.
Does it look changed in any way?
No, they look exactly how they were that night.
We offer Exhibit 9, Your Honor.
All right, any objections to the photograph?
No objections, Your Honor.
All right, 9 is admitted.
Again, Mr. Levin, can you tell the members of the jury what happened on these stairs?
Well, Jessica was walking down the stairs. She was on the lower half, and she tripped. She stumbled, and she grabbed the railing, and she also grabbed herself against Sonny, who was at the bottom of the stairs. And then Sonny said something.
What did he say?
Sonny looked at Frankfurt and laughed and said, "I think we might have to cut this one off."
Sir, did Sonny Mehta continue serving your table drinks after this incident?
He did. He didn't stop.
Sir, were there any other encounters you had with Sonny Mehta that you haven't already mentioned?
Yes, sir. It was towards the end of the night, I believe. And we were ordering drinks, and Sonny comes over, and Sonny looks at me and tilts his head at Jessica and says, "I hope this one's not driving."
Sir, again, did Sonny Mehta continue serving your table drinks after that incident?
Right after that, Sonny gave us shots. Sonny didn't stop.
When you left that bar that night, did you have another conversation with Jessica Marks?
I did. We were leaving, and I told Jessica, get in the Uber with me. You can come back and pick up the Impala tomorrow morning.
Objection, Your Honor, hearsay.
Okay, as to Mr. Levin's statements to
As
Ms.
to
Marks?
Mr. Levin's statements. That's
All
correct.
right. Mr. Atherton, response?
Yes, Your Honor, under 801C, this goes to the effect on the listener. Because of Morgan Levin's question, Jessica Marks responded, so it goes to the effect upon which it had on Jessica Marks.
All right, response from defense?
Your Honor, I believe the opposing counsel is using this to show that Morgan Levin was worried about Jessica Marks, and therefore it is still for the truth of the matter asserted.
Okay. Well, here's what I'm going to do then. If that's the representation for what it will be used for, I don't think that there's a danger that the jury will take it for any truth, particularly with this particular statement. So I'll again issue a limiting instruction to the jury not to consider it for any truth in Mr. Levin's statements, but just for any effect that it had, or I think alternatively, just to show that the statement was made or communicated.
Yes, Your Honor.
Mr. Levin, can you continue your answer?
Yes, sir. So I told Jessica, we'll pick up the Impala tomorrow, and she looks at me and she, walks in a straight line. She tries to walk in a straight line. She does this self-proctored sobriety test. And she says, "I've gotten pretty good at driving after a big night." And I wish I would have put my foot down and said, "No, you're getting in the Uber with me," but I let her drive that night.
Thank you, sir. No further questions, Your Honor.
All right.
Cross-examination, Your Honor.
Go ahead, Mr. Spillner.
Yes, Your Honor. Good morning, Mr. Levin.
Morning.
Now, I understand this must be difficult for you, but I want to talk about what happened shortly after Jessica Marks' death. Sir, it's correct that Ethel Marks, the plaintiff, originally threatened to sue you.
That's right. She said she was going to sue me when she found out what happened.
Now, Ethel Marks didn't follow through with this.
No.
That's right. She sued Sonny's rooftop bar instead.
That's right.
So now you're testifying in court today.
That's what I'm here to do, right?
For the same person that threatened to sue you.
I'm testifying for Jessica.
You spoke with Officer Sammy Gaskins right after Jessica's death, correct?
Yeah, I remember talking to the officer. I don't remember what I said, but yeah.
Now I'm showing you Exhibit 23, Officer Gaskin's report, which has been pre-admitted. Ms. Ortega, could you please display that on the screen? Now, it says right here that you originally told the officer that you had not been drinking that night. Does this refresh your recollection?
I might have said something like that.
All right, now I want to talk about Miss Marks' drinking history. In high school, you and Jessica went to parties.
We did, yeah. I would always be the one driving.
Now, Jessica normally had a couple drinks at these parties.
Yeah, not very many, just enough to get her on the dance floor.
It's correct that she drank almost every.
I mean, there were parties every weekend, so she drank a few drinks every weekend.
And in college, this drinking only increased.
I mean, I wasn't there with her at Drexel, but I assume she did drink a little bit more than she had in high school.
Now, I want to talk about what happened before you and Jessica Marks entered Sunny's rooftop bar. And now, you testified in direct that Miss Marks planned to stay in LA for spring break from March 18th to March 25th, correct?
That's right. Her flight came in on the 18th, and she was supposed to leave on the 25th.
Meaning that March 24th, the day at issue, was her last day of spring break vacation.
It was. She had classes in the evening on the 25th.
And I'm showing you Exhibit 6. You recognize this, correct?
If I remember correctly, this is a video that she took at her Airbnb. Yeah.
We offer Exhibit 6.
All right, any objection?
Yes, Your Honor. To lack a foundation, opposing counsel has yet to lay the foundation under 901 that this is authentic. If they do so, we'd be happy to withdraw.
Your Honor,
Okay.
here.
Go ahead.
Your Honor, I just asked I just asked Mr. Levin if he recognized this, and he answered that it was a video that Jessica Marks took of herself. Therefore, he has personal knowledge of this video.
May I respond?
Sure, go ahead.
Your Honor, evidence must be laid that the video or any image in question isn't altered in any way, and that it accurately reflects who the person is in the video, that she was acting that way on the night in question.
Okay, I don't think that's, I mean, that is true. I think his answer is sufficient to establish that, though. Here, if there's issues with that you think there are problems, you can, of course, redirect on it, but I think his answer is sufficient to establish that this video is authentic. He said it was her and taken of her in her apartment or Airbnb on the night of the incident. So I'm going to deem Rule 901 satisfied. You can continue questioning, defense.
Yes, Your Honor. Is Exhibit 6 admitted?
Yes, thank you for clarifying. My apologies. Yes, Exhibit 6 is admitted.
Yes, Your Honor. And Mr. Levin, this video was recorded on March 24th.
Yeah, it was.
Mr. Ortega, can you please play Exhibit 6?
Hey guys, we're going out tonight for a night on the town. We're going to a rooftop bar in Hollywood. Should be fun. You know, go hard or go home. Not ready to go home.
Now, in this video, Jessica stated to go hard or go home. Not ready to go home, correct?
That is what she said, yeah.
Now, to you, this can mean to go all out, to not hold back.
It could be. I've heard it used in that context before.
Sir, it's fair to say that to you, this expression could be used to indicate heavy drinking.
Yeah, I guess in some sense, yeah.
And Mr. Levin, I want to be clear. This video, it was recorded before Miss Marks ever stepped foot in Sunny's rooftop bar.
That's right. You're right.
Now, Miss Marks had 1 or 2 glasses of wine at her Airbnb. Is that right?
I'd say so, yeah.
Now, I want to talk about how you and Miss Marks got to Sunny's rooftop bar. And now, Miss Marks didn't take an Uber.
No, she didn't take an Uber. We went in her Impala that she rented out.
And that's right. Miss Marks decided to drive herself.
To drive the both of us, yeah.
Now, you testified on direct that Miss Marks interacted with Mr. Mehta, correct?
That's right.
However, it's true these interactions were never longer than a minute,
No, not really. I wouldn't say more than a minute, no.
In fact, they could have even been 30 seconds.
Maybe somewhere around there, yeah.
Now, I want to talk about what you testified in direct. I took some notes here. You testified in direct about Exhibit 10.
Exhibit 10, which one was that again?
That was the video of Jessica Marks at her bar, or at Sunny's rooftop bar.
Oh, right, the one where she's giving the Oscar speech. Okay, yeah.
That's correct. Mr. Levin, it's correct that Sunny Mehta was not nearby when this video was taken.
I don't remember Sunny being there, no.
And you never showed this video to any employees at the bar.
Why would we do that?
Is that a yes to my question, Mr. Levin? You never showed this video?
No, it was just to Jessica's followers.
Could you repeat your answer? Wait, are you saying that you did show this video to Sunny's rooftop bar?
No, sir, it was just to Jessica's followers.
Thank you for clarifying. Now, I want to talk about how you and Miss Marks planned on getting home. Now, you testified in direct that you planned on taking an Uber.
That's right, I did.
And before leaving Sunny's, you offered to Jessica that she could take this Uber with you.
I did tell her. I asked her when I should have just told her, yeah.
Now, Jessica didn't end up getting in the car with you.
No.
She ended up driving herself.
Yeah.
And Miss Levin, you stated on direct that Miss Marks said, "I've gotten good at driving after a big night."
She said that right to my face, yeah.
Now, I want to talk about Miss Marks' state when you left the bar. She gave her a sobriety test, correct?
She did something of the sort. I don't know if it was a joke or what.
Now, Miss Marks walked in a straight line.
Somewhat of a straight line.
And she touched her nose.
She did. I really think it was as a joke, like she was mocking sobriety tests somehow, but I don't know.
Well, Miss Levin, that's right. You think it's a joke, but you admit that Jessica Marks didn't look as drunk as you expected.
She didn't really seem as drunk as I had expected, sure, but she still got behind the wheel.
Objection, Your Honor.
As to what, Mr. Atherton?
I believe opposing counsel has ran out of time.
Your
right.
Honor, that was my last question.
All right. Okay. Well, my understanding is that at the expiration of the time, then, and I don't see time updates coming in the chat, but if that's both parties' understanding, then we'll end the record at the time that time expires. So,
Yes, Your Honor, that was my last question, so I'm okay with that.
all right. Okay. Then with that, any redirect examination for Mr. Atherton?
No redirect, Your Honor.
Okay. All right, then. Thank you very much. Mr. Levin, thank you for your testimony. You may be excused.
Yes, sir.
And Mr. Atherton, any further evidence that you'd like to present on behalf of the plaintiff?
No, Your Honor. The plaintiff rests.
Okay, thank you very much. Mr. Spillner, any evidence you would like to present?
Yes, Your Honor. The defense called Sunny Mehta to the stand.
Okay. Mr. Mehta is present on screen. You're presumed sworn, and Mr. Spillner, whenever you're ready, you can proceed.
Yes, Your Honor. Now, good morning, Mr. Mehta.
Good morning, sir.
Could you please introduce yourself to the court?
Yeah, my name's Sunny Mehta. I'm 28, was born and raised here in Malibu, and I've lived here all my life.
What was your profession as of March 2019?
I'm an entrepreneur. At the time, in March 2019, I was the proud owner of Sunny's rooftop bar, but I've moved on to bigger and better things now.
Now, let's talk about your experience as a bar owner. When did you first purchase your bar?
Sometime around February of 2017, bought it from this guy named Nathaniel Warner.
Now, what training do you have as a bar owner?
I was certified as a bar owner by the state of California, completed what they call a responsible beverage training course that was administered by the California Department of Beverage Control. We call it the ABC.
Now, what does your training cover?
Generally, they tell you what your obligations are and how to follow them perfectly, tell you how to identify signs of intoxication, and other things like that.
Now, did the other employees at Sunny's have the same training?
Oh, yes, of course. My interview process is thorough, and I always make sure that all my employees are trained.
I want to talk about the night of March 24th. Who was working with you that night?
You know, it was a Sunday night in the middle of March, so it wasn't too busy. It was just me and my coworker, Frankfurt Johnson. He worked behind the bar.
And now the night of March 24th, was Jessica Marks at your bar?
Yeah, you know, Jessica and her friend Morgan Levin, they walked into my bar around 9 p.m.
Now, who served Miss Marks and Miss Levin?
I served them, took their orders, delivered their drinks.
Now, you mentioned that you delivered the drinks. Who did you think was ordering more?
You know, every time I came around, they both ordered about one drink, so they had about the same amount, yeah.
Now, you mentioned earlier that you had training on intoxication. Now, as a bar owner, what types of symptoms do you look for to determine whether someone's intoxicated?
You know, there's no hard and fast rule, but a couple of the symptoms are slurred speech, their eyes get red or watery, if they're stumbling over, lose balance, lose motor function, that kind of thing.
Now, on the night of March 24th, did you see Jessica Marks exhibit any of these symptoms?
Oh, Jessica Marks, certainly not.
Do you remember about a specific instance in which Jessica Marks tripped into you on the stairs?
Jessica Marks? No, that never happened.
How many other customers did you have the night of March 24th?
In total, like I said, it wasn't too busy of a night. We had maybe 20 that night, but no more than 12 or 14 at one time.
And how many of those customers were you responsible for serving?
I took all their drinks and delivered their orders, but Frankfurt Johnson was mixing most of the drinks behind the bar.
Mr. Mehta, you said that there were other customers at the bar. Now I'd like to direct the court's attention to what's been pre-marked as Exhibit 26. It's the deposition transcript of Stevie Reger, another customer at the bar, who is unavailable to testify in court today. Your Honor, this is stipulated to be authentic and is admissible as an exception to the hearsay rule under Rule 804B1, former testimony by an unavailable declarant. Therefore, we would like to move for the admission of a few specific excerpts by reading them into the record. Do I have permission to display them on the screen constructively outside the presence of the jury?
That's fine. Let's take it part by part. If you're going to read just specific portions, then if there are any objections to those, let's assess them as they come in rather than admit everything right now. Because I understand that you're offering this under that particular exception for unavailable witnesses, but in the event that the specific statements you're eliciting violate other rules of evidence, I want to give the plaintiff an opportunity to object on grounds there or raise the issue that you just brought up if they disagree with it. So let's just go part by part, but yes, it will be outside the presence of the jury. So go ahead.
Yes, Your Honor. Now I'm showing page 2, lines 13 through 15. Page 4, lines 17 through 19. And page 5, lines 4 through 6.
Objection, Your Honor.
All right, go ahead. Grounds?
Pardon me, Your Honor, I withdraw. I didn't hear opposing counsel say 4 through 6. I thought they said 5 through 6.
Oh, I see. Okay. All right. So no objections. It's not no issues with this?
No objection, Your Honor.
All right, that's fine. Go ahead.
Those are all the excerpts, Your Honor.
Okay. Given that there are no objections from the plaintiff to those showings, we can go ahead and you can proceed.
Yes, Your Honor. Now I'll be reading the questions, and my second chair, Mr. Ortega, will be reading the answers. Now, page 2, lines 13 through 15. Question. We're here to talk about an incident that occurred on March 24th, 2019. Where were you at around 9 p.m. that night?
Honey's watching the end of the Lakers-Kings game.
Question. What'd you say? Excuse me. Page 4, lines 17 through 19. Question. Would you say that Jessica was visibly intoxicated?
Visibly intoxicated? I mean, she wasn't fall down drunk, but she didn't seem perfectly sober either.
And then lastly, page 5, lines 4 through 6. Question. Did you ever see Jessica stand up?
Probably. She was there a couple hours, but I didn't see her fall or stumble, if that's what you're getting at.
Now, Mr. Mehta, When you observed Ms. Marks on the night of March 24th, was she behaving in a manner consistent with Mr. Rager's testimony?
Oh, sure. No signs of visible intoxication. To the extent that she did stand up, there was no stumbling or falling down, but for the most part, I just took her orders at her table while she was seated.
Now, we just talked about Jessica Marks, and now I want to talk about Morgan Levin. How's the alcohol affecting him?
You know, Mr. Levin wasn't handling the alcohol too well. He was buzzed, not too bad, but definitely a little higher than Jessica was.
Did you think that Mr. Levin should be driving home?
Likely not.
What did you say to him about this?
You know, I looked at the two of them, Jessica and Morgan. I looked at Morgan. I said, hope this one's not driving.
And just to be clear, who were you referring to when you said that?
Morgan Levin.
Now, Mr. Mehta, I have one more thing to ask you. Why didn't you cut Jessica Marks off?
Well, I saw no reason to. As I told you, I'm trained by the state of California to identify all instances where I might need to cut my customers off. But Jessica Marks was displaying no signs of intoxication. She was talking clearly. She was making perfect sense. She ordered her drinks just fine.
Thank you, Mr. Mehta. I have no further questions.
All right, thank you very much, Mr. Spillner. Mr. Atherton, cross-examination.
Yes, Your Honor.
Go ahead.
May I proceed?
Yes, you may.
Good morning, Mr. Mehta.
Good morning, sir.
I found it interesting on direct examination. Opposing counsel asked you 6 questions about Stevie Redger, and I have them written right here. But sir, you would agree with me, you never told opposing counsel that Stevie Redger actually had a drink with Jessica Marks, right?
No, I didn't tell him that.
Sir, you first saw Jessica Marks at 9 p.m., right?
That's right. That's when she and Morgan Levin walked into my bar.
Served her some wine, right?
Yeah, I served him a red decoy blend.
You carded them, right?
Of course I did.
I want to talk about that card. Sir, you were able to tell that that card was fake within 2 seconds during your oral deposition, right?
Yeah, when you
Objection,
and
Your Honor. Relevance on multiple grounds. So, Your Honor, may I be heard?
Go ahead.
Yes, Your Honor. Jury instruction 11 states that it doesn't matter whether or not Sonny Mehta knew Jessica Marks was lying about her age to prove the plaintiff's cause of action. And additionally, there has been no foundation laid that Ms. Marks or Mr. Levin use a fake ID. As Mr. Mehta just testified, he doesn't remember a specific instance of that happening.
Okay, response from the plaintiff?
Yes, Your Honor. Under 401, evidence is relevant in the event it pertains to a fact and consequence. Now, fact and consequence in today's case, Your Honor, is how Jessica Marks and Morgan Levin entered the bar that night. The answer to that is the negligence of Sonny Mehta, as he saw that the ID was fake, but still let them in.
Your Honor, may be heard?
Sure.
Your Honor, Sonny Mehta's own negligence is irrelevant, as the affirmative defense in this case only calls for Jessica Marks' negligence. And for the plaintiff's cause of action, it doesn't matter whether or not Sonny was negligent. All that matters is that Jessica Marks was obviously intoxicated to a reasonable person. Your Honor, the charges of this case do not relate to Sonny Mehta's negligence.
May I respond?
Yes.
Again, we would direct the court's attention to pretrial order 13, as it states that Frankfurt Johnson and Sonny Mehta, the 2 workers at Sonny's rooftop bar that night, were acting on behalf of the defendant. They were representatives of the defendant, Your Honor. Therefore, they were acting on behalf of the defendant. And Sonny Mehta's negligence is absolutely not just important, but imperative for the members of the jury to understand.
Your Honor, may be heard?
Okay, last word.
Your Honor, opposing counsel has not addressed the point that Sonny Mehta's negligence is never stated in either charge, in either the affirmative defense or the cause of action. Therefore, it's not relevant. Just because Sonny Mehta and Frankfurt Johnson acted on behalf of the bar does not mean that this evidence is relevant to the charges, Your Honor.
Okay, so I'm going to overrule the objection on the grounds that this does relate to at least the bar representative's knowledge, and that is an element of the claim here under the Dram Shop Act. So given that understanding, I think we've been throwing around the term negligence. We are clear this is not a negligence claim, but knowledge does need to be proven. And insofar as the company is acting through its agents, the 2 individuals working at the bar that night, what they saw and what they knew is relevant to that. You can take it up in closing, you can take it up on redirect, but at least so far as relevance is concerned, it is admissible for knowledge. So with that, I'm going to overrule the objection. Thank you, both parties.
Yes, Your Honor.
Sir, again, you were able to tell that ID was fake within 2 seconds during the oral deposition, right?
Yeah, when they showed me the little ID over the deposition, I could tell it was fake immediately. It was missing several key details that would be present in a real ID.
Sir, you never thought that ID was fake on March 24th, 2019, did you?
Well, I don't remember every single ID I saw, but if I'd seen a fake ID that night, I would have let those customers in.
Sir, is it your testimony you did not look over that ID?
No, I'm sure I saw an ID from Jessica Marks and Morgan Levin. I'm just not sure it was that specific ID.
Well, sir, let's talk about what you served Jessica Marks. Again, red wine, correct?
A red decoy blend, that's right. It's a mix of Merlot and Cab.
Now, this is the receipt that you had for Jessica Marks that night, right?
That's right.
It's a fair and accurate copy.
I'd say so. This is all the drinks I served and the prices that they were at, yeah.
It hasn't been altered in any way.
Not from what I can tell, no.
Plaintiff offers Exhibit 17, Your Honor.
All right, any objections?
Yes, Your Honor, on hearsay grounds, Your Honor, the opposing counsel has not laid the foundation, the necessary foundation, that this was produced in the regular course of business.
May I respond?
Yes.
This falls under 801, Section D, subsection 2, as an admission by a party opponent, because Sonny's Rooftop Bar was the individual or the entity that produced this document.
Response to that?
Your Honor, yes, Your Honor, a couple parts of this, as opposing counsel is not offering a redacted exhibit, a couple parts of this exhibit are not made by Sonny's Rooftop Bar, specifically the $149.58 on the total tab and the Morgan Levin signature. Your Honor, those aren't admissions by a party opponent. And because the opposing counsel is not offering a redacted exhibit, that means this is still inadmissible, Your Honor.
May I reply?
Sure, go ahead.
We'd be happy to constructively redact the blue portions of the document.
All right, that's fine. Then why don't we redact all of the wet ink sections, including the signature and the gratuity and the total, and then the rest of it, it appears that there's enough foundation that these drinks were served and that this was a statement produced by Sonny's Rooftop Bar. So I think it does qualify as an admission. So with that understanding, it'll be admitted.
Yes, Your Honor.
Again, sir, red wine, right?
The decoy red blend, yeah.
3 alcoholic seltzers, White Claws, right?
Yeah, White Claws.
A beer, correct?
An IPA.
Another beer, correct?
Yep, another IPA.
2 shots, right?
2 green tea shots, yeah.
Sir, you individually served Jessica Marks drinks all of these beverages, right?
Well, I served them to the table with Jessica and Morgan. I didn't hand them into Jessica's hands, of course, no.
Sir, you were the only employee to serve that table, right?
Yeah, it was just me and Frankfurt that night, so I was taking orders from everyone on the rooftop. Frankfurt was mixing the drinks.
You were able to tell what Jessica Marks' demeanor looked like throughout the evening, true?
Sure. In the times that I interact with her at the table.
Ms. Rowell, can you screen share Exhibit 10 for us?
Hi, everyone. Morgan and I are in Hollywood. We're at a bar. It's kind of like a silly bar, except everything is really, really expensive. $10 for a seltzer. And everyone here wants to be a model or an actress. I'd like to thank the Academy. Mom and Dad, you've inspired me. Okay, well, go big or go home.
Sir, it's your testimony today that Jessica Marks did not look intoxicated in this video, right?
I wouldn't say she's definitely not intoxicated. I would say she sounds, possibly drunk in that video.
Sir, as a bar owner, you know that you had a legal duty to make sure your customers didn't drive intoxicated, right?
Of course. If I see someone that's pushing their limits, I cut them off immediately. They're done.
Sir, you can't deny that at 11 o'clock you heard Jessica Marks say, "I'm driving," right?
Sure. And for someone who's perfectly sober, that's totally fine.
You did nothing in response, did you?
She wasn't displaying signs of intoxication, so of course not. I'm not going to stop someone who's sober from driving.
Sir, in your direct examination, you talked about the training you underwent to become a bartender. Now, in that training, you learned that it is illegal for a person to drunk if they have a blood alcohol concentration over 0.08%, correct?
Right, that's the legal limit for someone to use a motor vehicle.
Ms. Rowell, can you screen share Exhibit 22 for us? And could you highlight toxicology paragraph? Mr. Mehta, please read along silently as I read aloud. Blood drawn at scene of accident contains 0.16 grams per 100 milliliter of blood. Did I read that correctly?
Sure, you read that right.
In other words, Jessica Marks, after the accident, had a 0.16 blood alcohol concentration, right?
That's right.
The accident happened after she left your bar, right?
Sure.
The bar that you individually served her at, right?
Yeah, Sunny's rooftop bar. Pride and Joy. Or it was.
Sir, after the accident, you were interviewed by Detective Sammy Gaskins, right?
I was.
You told Officer Gaskins Jessica Marks was a typical buzzed girl, right?
Oh yeah, I mean, I'd served her and Morgan a couple drinks, so it's clear that they had to have been buzzed, but they were displaying no signs of being buzzed, if that's what you're asking.
Sir, buzzed driving is drunk driving, right?
Of course, but I'm not liable if they made the choice to go and drunk drive.
Well, sir, that 19-year-old, college attending, and in your words, typical buzzed girl, she died that night, didn't she?
Yes, and I'm so sorry for the Marks family, and of course for Morgan Levin.
After attending the one and only Sunny's rooftop bar, right?
They decided to come, had a couple drinks, and Jessica drove off.
Is that a yes to my question, sir?
Yes, like I said.
Thank you, sir. No further questions, Your Honor.
All right, thank you very much, Mr. Atherton. Any redirect examination, Mr. Spillner?
Yes, Your Honor.
Go ahead.
Now, Mr. Mehta, turning your attention back to Exhibit 10, Mr. Atherton asked you about this on a cross-examination. Now, Mr. Mehta, did you ever see this video on March 24th?
Oh, of course not. I never saw that video, and I never saw her displaying symptoms like the ones she might have been displaying in that video.
When was the first time that you saw this video?
When they showed it to me at my deposition.
Thank you, Mr. Mehta. Nothing further.
All right, thank you very much. Any recross examination?
No recross, Your Honor.
All right.
Witness be excused.
Yes, you may step down. Thank you for your testimony, Mr. Mehta.
And at this time, the defense rests.
Okay, thank you very much, Mr. Spillner. Then with that, we'll proceed to closing arguments. Mr. Atherton, are you ready to proceed?
Yes, Your Honor.
All right. Yes, go ahead. And while you're doing that, Mr. Spillner, anything else that you want to take care of before we move on to closing arguments?
No, Your Honor. Nothing further.
Okay, great. Then Mr. Atherton, whenever you're ready, you can proceed.
May it please the court. Members of the jury. This is Jessica Marks before March 24, 2019. This is Jessica Marks after March 24. Liver lacerations, neck vertebra severely damaged, skull fractures, even brain damage. All of this leading to her death. But members of the jury, why? Why did this have to happen? It's because the business that served her chose not to save her. Now again, we were the plaintiff in today's case. We have to prove to you, by preponderance of the evidence, that the defendant is liable for the wrongful death of Jessica Marks. Today, we fulfilled our burden, and in doing so, we proved three things to you. One, Jessica Marks was a minor on March 24th, 2019. Two, the defendant continued serving Jessica Marks drinks after she was obviously intoxicated. And three, those drinks caused the death of Jessica Marks. Now, as the court is about to instruct you, here in California, we have a law that specifically addresses why we're here today. It's called the Dram Shop Act. Now, this law states that when a bar continues serving a minor alcohol after the minor is obviously intoxicated, that bar can and should be held liable. So let's talk about the defendant's actions. Sonny Mehta testified Jessica Marks was not obviously intoxicated. But don't forget, Sonny Mehta testified he went through the training to become a bartender, as did all the other employees of the bar. So they knew exactly what would happen when a 19-year-old, 5 feet tall, 115-pound girl drank that much alcohol. At the very least, she would be intoxicated. Even if Sonny Mehta never saw Jessica Marks obviously intoxicated, he knew exactly how petite she was. He served her every single time. He didn't say it. 2 seconds. That's all it took. 2 seconds for Sonny Mehta, acting on behalf of the defendant, to look at the fake ID Jessica Marks gave him. 2 opportunities to stop what was about to happen. 2 chances. 2 seconds to save Jessica Marks. But the defendant didn't take those chances. I want you to recall the events of that night. Remember how many times the defendant interacted with Jessica Marks in an obviously intoxicated state. First, Sonny Mehta saw as Jessica Marks entered the bar that night. He then received and served the order for the wine, received and served the order for the 3 alcoholic seltzers, received and served the order for the beer, received and served the order for the shot. Those right there are 9 instances. 9 times the defendant was within feet of Jessica Marks in an obviously intoxicated state. 9 breaches of duty, and not 2 seconds to stop. But those weren't it. As Morgan Levin testified to, Sonny Mehta saw as Jessica Marks stumbled down the bar that night. He responded to this by saying, "Whoa there, we might need to cut this one off." But again, that wasn't the only time. As Morgan Levin testified to at their table, Sonny Mehta came to their table and asked Morgan Levin in reference to Jessica Marks, "This one's not driving home, right?" And as Sonny Mehta testified to, he watched as Jessica Marks left the bar that night. That leads us to the most important part of today's case, the number 12. 12 times, members of the jury. 12 opportunities the defendant had to stop what was about to happen. 12 chances to save Jessica Marks. But the defendant didn't take those chances. Instead, the defendant continued serving. Find the defendant liable. Thank you.
Thank you very much, Mr. Atherton. Mr. Spillner, closing argument?
Yes, Your Honor.
Go ahead.
Ladies and gentlemen, this is a case about choices. And Jessica Marks' own choices led to her death. None of this ever would have happened if Miss Marks hadn't chosen to get a rental car and chosen to drive that rental car to Sonny's, even though she knew her plan was to go hard. None of this would have happened if Jessica Marks hadn't chosen to order drinks, even though she was under 21, and chosen to drive herself home. Again and again, those choices added up. Sonny Mehta, he didn't make any of those choices for Jessica Marks. She made them herself, and she is responsible for those choices, not Sonny's rooftop bar. And now the plaintiff has the burden of proof that Sonny's rooftop bar served Miss Marks alcohol when she was obviously intoxicated. Now it's very clear when you look at all the evidence that Miss Marks was not obviously intoxicated the night of March 24th. And you heard from Sunny Meta that Miss Marks did not look or act physically intoxicated. And Mr. Levin knew what, Mr. Meta knew what signs pointed to an obviously intoxicated person. He'd owned the bar for 2 years by that time, and he'd received training from the state of California on how to identify an intoxicated person. And when Mr. Meta looked at Jessica, he saw nothing out of the ordinary. Now, Mr. Meta's testimony is backed up by the only third-party witness in this case, the only neutral witness without any stakes in the matter, Stevie Rager. Now, you heard today that Mr. Rager believed Miss Marks was not obviously intoxicated, or not fall down drunk. And he supported Mr. Meta's statement that Jessica Marks, she never stumbled that night. And Mr. Atherton argued in his closing that Jessica Marks was obviously intoxicated. But ladies and gentlemen, what you have to remember is that obvious intoxication, it doesn't mean obvious to Jessica Marks' best friend, Morgan Levin, who'd known her for years. And it does not mean obvious to Jessica Marks' followers on Instagram. Now, what obvious intoxication means is obvious to a reasonable person at the scene who was serving Miss Marks alcohol. Sunny Meta never saw Jessica Marks obviously intoxicated, much less even have the opportunity to observe such a thing. He was only at her table for 30 seconds at a time. There were 20 other customers at the bar, 20 other people that Mr. Meta had to attend to. He had to take the other customers' orders, bring their orders, clear their dishes, and process their payments. His attention wasn't going to be focused on Miss Marks solely because he had a job. And now Mr. Atherton also entered Exhibit 10 into evidence, which is the video of Miss Marks at Sunny's. Now, the key thing to remember, ladies and gentlemen, is that Sunny Meta never saw this video. Now, even Morgan Levin herself testified today that at the end of the night, when Jessica did a field sobriety test on herself, she was able to walk in a straight line and touch her nose. That's not someone who's obviously intoxicated. Now, Morgan Levin even admitted that Miss Marks didn't look as drunk as she originally thought. And it's not surprising that Miss Marks wasn't obviously intoxicated, because as you heard today, she was accustomed to drinking. And since high school, Miss Marks was used to having several drinks every weekend. And during college, she drank even more. Now, Mr. Atherton has mainly relied on the testimony of Morgan Levin to prove his case. Now, he mentioned 2 specific instances where Sunny should have stopped Jessica, but both of those instances were testified to by Morgan Levin. And you heard today that Mr. Levin's credibility is in serious question. He was threatened by Ethel Marks, Jessica's mother, meaning he had every incentive to point the finger away from himself. Mr. Levin lied to the police when he said he wasn't drinking that night. He lied about his age, and on the night of March 24th, was very drunk himself. So you can't consider his testimony. Now, in short, there just isn't enough evidence that Miss Marks was obviously intoxicated, so you shouldn't find Sunny's rooftop bar liable. But ladies and gentlemen, even if you conclude that Miss Marks was obviously intoxicated, you still can't find Sunny's liable. And now the defense is pleading an affirmative defense in this case, called comparative negligence. And what this means is that you have to look at the fault of Jessica Marks in her own death. So let's look at her choices. Now, first of all, you have all of Jessica's choices before she even stepped foot in Sunny's rooftop bar. She rented a car. She drank 1 to 2 alcoholic drinks at her Airbnb, where she said her plan was to go hard or go home. And this next one's critical, ladies and gentlemen. And if you have a plan to go hard, wouldn't you take an Uber to the bar, knowing that you were planning to drink a lot? But Jessica Marks chose to drive herself to the bar, knowing then she'd have to drive it all the way back home after a hard night of drinking. That was her decision. So already, you have Jessica Marks' faults adding up before Sunny Meta even served her a single drop of alcohol. Now, Miss Marks' bad choices didn't stop when she got to Sunny's rooftop bar. And now when she got there, she and Mr. Levin ordered at least 8 alcoholic drinks with the knowledge that they were both underage. Now, if Miss Marks hadn't ordered these alcoholic drinks in the first place, if she hadn't decided to drink underage, if she hadn't decided to break the law, there would have been nothing to serve. And finally, Miss Marks chose to drink and drive. She not only endangered herself, but she endangered the lives of other people. Ladies and gentlemen, the truth about this case, even if it is upsetting, is that over and over again, Jessica Marks made bad choices that led to her death. And the most significant one she made before Sonny's Rooftop Bar ever served her a single drop of alcohol. As a result, you should find Sonny's Rooftop Bar not liable. Thank you.
Thank you very much, Mr. Spillner. Rebuttal from the plaintiff?
Yes, Your Honor.
All right, go ahead.
Opposing counsel wants to talk about choices. Jessica Marks made choices that way. That's true. They were choices we wish didn't happen. Members of the jury, remember who gave her the choice. Who provided her that option? Who gave her the opportunities to drink all alcohol? In fact, let's talk about the defendant's mind. You only live once. March 24th, 2019, the defendant acted by the mind. The defendant lived by the mind. The defendant served by the mind. And because of the defendant's decision to serve, as opposing counsel forgot to say in his closing argument, Jessica Marks won't go home. Jessica Marks wanted to go home, but she didn't. Why? Why couldn't she go home? Because the defendant chose to serve. The defendant chose to not save. Find the defendant. Thank you very much.